For those with global assets, there's a structure that operates on a different level of protection. Imagine a U.S. court issues a judgment against you. Now imagine that judgment is effectively powerless because your assets are held beyond its reach. This isn't just a legal theory. It is a practical fortress. Attackers face massive financial hurdles before they can even begin a challenge. In a jurisdiction like Nevis, a creditor might have to post a $100,000 bond just to get their lawsuit in the door. So how do these work? We'll break down the immense benefits, the critical dangers, and the rules you absolutely must follow. Before we go further, let's establish the foundation. At its center, a foreign express trust is first and foremost an express trust. The foreign label isn't about where the assets are. It's a strict legal test defined by the IRS. A trust is foreign if it fails either the court test or the control test. The court test. Can a U.S. court exercise primary supervision over the trust? If no, it is likely foreign. The control test. Do U.S. persons control all substantial decisions? And substantial decisions isn't vague. It means deciding when to distribute funds, choosing beneficiaries, making investment choices, or even deciding to sue someone. Because of this difficulty, many think these are shady or illegal. That's false. Foreign trusts are completely legal instruments when set up and reported correctly. So, a foreign trust is a deliberately created structure where key control or legal supervision resides outside the United States. This specific design is the source of its power. Now let's look at why this works. The protection is not magic. It's about jurisdiction. A U.S. court's power ends at the U.S. border. It cannot compel a foreign trustee. This creates a powerful shield against many types of creditors, including claims from contentious divorces, business lawsuits, or even forced inheritance claims. The trust is governed by the laws of its home country. Strong asset protection jurisdictions have laws specifically designed to be unfavorable to outside creditors. This separation also creates tax efficiencies. For e.g., if a foreign person creates a trust for U.S. beneficiaries, that trust is typically only taxed on its U.S. source income. This structure is also potent for estate planning. It can allow a settler to bypass rigid, mandatory inheritance laws, giving them true control over who inherits their wealth. This all sounds incredibly powerful. But does this protection come with hidden dangers, especially when it comes to U.S. taxes for U.S. beneficiaries? So, where are these trusts established? Popular choices include the Cook Islands, Nevis, Bermuda, and the Cayman Islands. Case in point, Nevis. As we mentioned, a creditor may have to post a $100,000 bond just to be heard in court, a massive deterrent. Another case, a business owner wants to leave their company to one capable child, not all three. A foreign trust can make that possible. Final case, an entrepreneur places assets in a foreign trust years before marriage. During a contentious divorce, those assets are outside the jurisdiction of the domestic court. We've seen the power. But this level of protection isn't simple or without risk. Now, we have to talk about the difficulty, the costs, and the tax traps. Remember we asked about hidden tax dangers? Here's the biggest one for U.S. beneficiaries, the throwback rule. When a trust distributes accumulated income later, the IRS taxes it. It gets worse. Let's say the trust has years of capital gains. Under the throwback rule, when that money is finally distributed, those capital gains lose their character. They are converted and taxed as ordinary income at the highest marginal rates, plus interest. A poorly structured distribution can wipe out a huge portion of the trust's growth. Beyond taxes, there's a mountain of paperwork. The IRS demands extreme transparency. U.S. individuals must file reports like Forms 3520 and 3520A. And the penalties for failing to file or filing incorrectly are draconian. We're talking tens of thousands of dollars, or even a percentage of the trust's assets. So we have this immense power on one side, and this crushing difficulty on the other. How do these two sides connect? Are they related? Here is the key insight. They are two sides of the same coin. Remember the court and control tests? The features that give protection are what trigger the intense IRS reporting. The difficulty isn't a bug, it's a feature. But it is a feature that demands professional navigation. You cannot achieve the benefits without taking on the compliance burdens. This is why these trusts are not for everyone. They are highly specialized tools for individuals with significant international assets or unique high-stakes risks. So, the Foreign Express Trust offers exceptional asset protection and planning opportunities by placing assets beyond the reach of domestic courts. But this power has a price. They are a potent strategy for the right person, but they demand careful planning, expert legal and tax advice, and ongoing, diligent compliance. If you believe this tool might be right for you, your first step should be to consult with specialists specializing in international asset protection. This is not a DIY area. Used correctly, a foreign trust is not about hiding money. It is about structuring your legacy to be resilient, secure, and truly global.